Charity Kisotu, you are welcome.
Thank you, Commissioner.
Good evening, Judge.
Good evening.
Omwanzo Mbati, welcome.
Thank you, Commissioner.
Good evening, Jokindomu.
Good evening. Thank you.
Good evening, Judge.
Good
Anton
evening.
Rima, karibu Judge.
Thank you, Commissioner.
Good evening, Judge.
Good
Fatuma Sichale, karibu sana.
Thank you, Commissioner.
Good evening, Judge. Oluwande Evelyn, you're welcome.
Thank you, Commissioner.
Good evening, Judge. Dorcas Odwor, Senior Counsel and Attorney General.
Thank you, Honorable Attorney General.
Thank you for that introduction. Judge, you start by telling us your county and your ethnicity.
I come from Machakos County. I come from the Kamba ethnic community.
Very well. You start by telling us, or you paint for us a picture or a presentation of who is an ideal Court of Appeal judge. And then you tell us how you fit that bill by briefly telling us about your qualifications, skills, knowledge, expertise that makes you suitable for that position of a judge of appeal.
Thank you, Honorable Chief Justice. Let me start by saying that an ideal judge must have both software and hardware.
Mm-hmm.
By hardware, I mean that you must be qualified and you must have the paper qualifications that are needed in the books. That is hardware. By software, you must have the soft skills that are needed when you are determining cases. That means a listening ear, patience, and virtues such as that. That is soft. It's not in paper, but that is what you need to be a good judge. Now, talking about myself, my name first is Munyao Sila. I am a judge of the Environment and Land Court. I was appointed a judge of this court in the year 2012. I am among the 15 pioneer judges of this court. I have therefore served for a period of 13 years, and this is my 14th year. Prior to being appointed as a judge, I was in private practice. I was also a lecturer at Moi University School of Law, where I taught criminal procedure and property law. Academically, I hold a Bachelor of Laws degree from the University of Nairobi. I also hold a postgraduate diploma from the Kenya School of Law. I also hold a master's degree from the University of London. I also hold a postgraduate diploma from the UN Institute of Training and Research in international environmental law. I have in my practice as a judge been very keen to develop jurisprudence. I'm proud to say that I have enriched the jurisprudence of law in the field of land and environment, and I think part of my decisions actually form the bedrock of the jurisprudence of this court. If I may just say one of them, the concept of root of title is actually a concept that I developed in my jurisprudence, and it has been endorsed even by the Supreme Court. Apart from jurisprudence in courts, I have also done quite some research and written documents and papers out of court. I have authored a book on criminal procedure, that is modern law of criminal procedure in Kenya. I have also authored a book chapter in the book Environmental Governance, which was edited by Professor Kameri Mbote and Professor Kibugi of the University of Nairobi. I have also written numerous other papers. I have presented in conferences locally and internationally. I have been involved in the training of judges. I have prepared papers and availed them for purposes of training of judges. I have presented papers in judges' annual colloquium. I have been a trainer of magistrates on land law. I produced a primer on land law, which I presented on the training of magistrates. I have been involved in writing of various documents. Apart from my writing administratively, I have been the presiding judge in Kisii. I am currently the head of the Environment Division of Environment and Planning Division of the Environment and Land Court in Nairobi. I'm a member of the steering committee of mediation. I have also served as chairman of the KMJA in South Nyanza region. Going to the software now, I have utmost integrity. I am patient. I treat litigants fairly. I'm very fair, both advocates and litigants. I do not leave any place that I have served in the way I've left it. I always leave a place better than I found it. And maybe
Very well.
because of that,
Yeah.
the Southwest Kenya Law Society awarded me Judge of the Year 2025, and I'm proud of that achievement.
Well done.
Thank you.
So you are both a scholar, a jurist, and a judge.
I wear those hats, my dear.
Thank you very much. The next set of questions will be read by Commissioner Mwanza.
Thank you.
Thank you, Judge. I confirm that you serve my people.
Yes, I do. Thank you.
All right.
Yes. I
Um,
used to now. Been transferred to Nairobi.
all right.
Reported last week.
All right.
Yes.
Welcome to Nairobi.
Thank you.
Shamba la mawe.
Thank you. Yes, sure.
All right. Judge, one of the key attributes of judge craft is judicial courage. What is your understanding about judicial courage, and what are the key aspects? That's the first. Second question, and lastly, are you able to demonstrate in your years? Is this your 14th year?
14th year.
Yes. 14th year of judgeship, an instance or instances, one or two, when you've exhibited judicial courage?
Thank you, Commissioner. My understanding of judicial courage is that a judge must be ready to make bold decisions. Now, the decisions of a judge may not necessarily be palatable to the public or to other sectors, but a judge must be bold enough to make those decisions. They may in fact go against what the public expect, but those decisions must be made. In my career as a judge, I have definitely made very bold decisions. I have made decisions touching on cancellation of title for huge tracts of land. I have made decisions on environment that touch on the public, and I could say that those are bold decisions.
Okay.
Yes.
Judge, I don't know whether I read that decision where I don't know whether it was you said that children cannot inherit their father when he's alive.
Yes.
You are the one who made that decision?
I made that decision. That is the case of Ongaga.
Yes. Just summarize it for us.
The facts of the case?
Just the holding.
The holding.
Yeah.
Well, my holding was that children do not have a right to compel their parents to allocate them land while their parents are still alive.
Yes.
So there is no right on the children to compel them.
Okay.
Yes, if your parent wants to give you land when he is alive, that is his prerogative, so long as that is his or her land.
Thank you.
That in a nutshell was my whole.
Thank you, Judge. Judge, you appreciate that our Constitution is a progressive document.
I appreciate it.
And Article 260 of the Constitution.
May I refer, Commissioner?
Yes.
Very well.
Yes, actually, that's why it's the Constitution is there. So Article 259 of the Constitution
Yes.
provides that the Constitution shall be interpreted in a manner that A. promotes purposes and values and principles, B. advances the rule of law, human rights and fundamental freedoms, permits the development of the law, and that is where I'm most interested in.
Well,
C. Permits the development of the law.
yes.
Judge, you have a matter hypothetically, of a 70-year-old man who has three children, and is at the end of his life. He has stage 4 cancer, and the doctors have given him weeks to survive, weeks to live. He's in great pain, and needs a solution out of it. So he comes to your court under certificate, files a petition under certificate, and in the certificate he requests that a medical practitioner be allowed to assist in ending his life. Number 2, that the medical practitioner should not be held accountable and shall be free from any civil, criminal, or disciplinary liability. And 3, which is why I was citing for you that article, that the common law be developed in line with the Constitution to give effect to his wishes. There is evidence that this is a highly educated person. Probably he's an advocate of more than 40 years and served all over the country. And there is a psychiatric report saying that he has what do you call it? He's in his element. He has all his mental faculties to be able to make that decision. Judge, how will you navigate this?
Let us start by understanding that you can only take a life of a person if it is provided by law. That is what Article 26 of the Constitution provides, that there is a right to life. Now, it would not be material that this gentleman believes that he has a few weeks left.
It's actually not a belief. There is a medical evidence to support that proposition.
Very well. It still would be immaterial, in my opinion, unless he can point to a particular law that says that you can take my life. Now, we are not there yet in Kenya. There are some countries that allow for that, but, well, as long as he's in Kenya and he's a Kenyan, then unfortunately he cannot avail himself of that.
Judge, just before you conclude on that,
Yes.
There is the right to dignity.
Yes.
So even as you balance the right to life, there is a right to dignity. He says he has the right to dignity, and he has the right to have a dignified death.
Very well, that's fine. You see, we can still give you dignity even as you await your death. That is why we have palliative care. We can take you to a hospice. We will treat you well, but we will respect your right to life.
Is that based on your interpretation of the Constitution, or on your belief or faith?
This is based on the interpretation of the Constitution at Article 26, because it says, as I'm saying,
Yes.
unless it is authorized by law,
Yes.
then you cannot take somebody's life. So the doctor cannot take his life because it is not authorized by law.
But he says that the doctors have said he has no prospect at all of life beyond a couple of weeks. He has the right to dignity, to autonomy in terms of his bodily autonomy. And then he's saying, I've come under 259 C, and I'm asking, develop the law, allow me to die in dignity.
Very well, we will develop the law in so far as we will allow him to die a dignified death. but we are not going to take away his life. By the way, Commissioner,
Yes.
you know we are all on borrowed time. Yourself, myself, and all of us, we have a lifespan. But it is not for us to say that, end my life now, we leave that to God. And so long as the law, as I am saying, does not allow for that, then we must respect that. We will still give you dignity.
Thank you.
Yes.
Judge, I have one more question on spousal consent, since this is something that you deal with in your division. I think under the Section 12 of the Matrimonial Property Act,
Yes.
and the Land Registration Act, Section 93, provide for a spousal consent in terms of matrimonial property or property that is acquired in course of matrimony. Now you have a man who's polygamous and he wants to dispose part of his asset to settle school fees. He has 2 wives and he needs to sell this, but there is the requirement of spousal consent. Would he need spousal consent from his 2 wives or from his first wife? And if such a transaction is challenged, would it be void?
Very well. I think let's start first by understanding what matrimonial property is.
Yes.
Matrimonial property would constitute the matrimonial home,
Yes.
number one. Then it will constitute property that is acquired in the course of marriage,
Yes.
and that is jointly registered in the name of the spouses. Now, it depends if this is actually matrimonial property or not. It may not be matrimonial property because it may be property that he acquired before the union.
No. This is acquired during the union of his 2 wives.
Well,
Both of them are married to him.
yes. Now, it depends on what kind of property. Now, if it is property that was acquired before, let's assume he has 2 wives, all right?
Yes.
So if it is property that he acquired before the second wife came into the picture,
No. Both of them were in the picture.
oh, all right, fine, very well. So if it is property that was acquired when both of them were in the picture,
Yes.
then that would constitute matrimonial property because it was acquired, of course, during their union. And in this instance, in my opinion, he would require consent from both spouses because that property was acquired at a time when both spouses were in the picture.
All right. Thank you. Thank you, Judge.
Thank you.
Thank you, Honorable CJ, and Judge, welcome once again.
Thank you, Commissioner.
I'll take you, Judge, to the famous Muruatetu case. And although this may not be your daily terrain at the ELC, but I'm so sure that you must be alive to what Muruatetu is all about. Now, there's Muruatetu 1 and Muruatetu 2. Which is this issue which was raised in Muruatetu 1 and which was eventually clarified in Muruatetu 2?
Thank you, Commissioner. As you say, it's a notorious case. And in as much as I do not see it in criminal cases, yes, that's a case that I'm familiar with. What happened in Muruatetu 1 is that the Supreme Court was looking at the validity or constitutionality of the sentence of death in a case of murder. Murder, of course, the offense is provided for under Section 203 of the Penal Code. Then you have the sentencing provision in Section 204 of the Penal Code. So what the Supreme Court ruled is that the way Section 204 is couched, because it is couched in a manner to suggest that the death penalty is the only sentence. So the Court of Appeal clarified, the Supreme Court, clarified that and said that it is not a mandatory sentence.
Yes.
This death sentence is not mandatory. Now, where Muroteto 2 comes in
Yes.
is that other courts were extrapolating the decision in Muroteto 1 to other criminal cases that provide for mandatory sentences or minimum sentences and applying them to those other cases. For example, cases under the Sexual Offences Act, they have provided for minimums. And courts were now using Muroteto 1 to apply that to other criminal cases. Now, where Muroteto 2 comes in is a clarification that the case only decided section 203 and 204 of the Penal Code. That is validity and constitutionality of the death sentence in respect of murder cases.
Impressive, Judge. I'm happy that you have it right on your fingertips, and yet you are not in the mainstream criminal high court. Thank you. Now, let's get back to ELC and an area where you have stated that you've done a lot in. This is the area of investigation of titles. And I have no doubt about that court. And there are two decisions of the Supreme Court on two ways in which titles can be investigated. Now, which mode of investigation did you first of all settle for?
Root of title. You have to get to the root of title.
Root of title.
Well, yes.
Okay. And the dinner, I think it's the dinner case,
Yes.
affirmed that.
Yes.
There's another decision which says you go to the other side. You do not need to go to the root of title, you just do a search and that suffices. Is it so?
I'm not aware of that decision from the Supreme Court. What I'm aware from the Supreme Court is the dinner principle, that you need to exercise due diligence and get to the root of title. And for your title to be valid, it has to have a genuine root of title.
Okay. Now, these challenges which you highlighted in your decisions about the state of the registries, in fact, you stated in one of your decisions that it is too messy, that even holding a title in your hand, you are not very sure whether it is a title or it is just a piece of paper. You remember that, Judge?
I remember the case.
Yes. Do you think that the affirmation of this manner in which titles ought to be investigated settles all these challenges which you highlighted in maybe in your decision?
Unfortunately, it does not. And the reality of investing in land in Kenya is that it is now a minefield. You may not, in fact, know whether you hold a genuine title or not. That's just the reality that we face. And in my opinion, what we need to do is actually to clean up our land registries and have security in terms of titles, so that when a title is issued, there is that guarantee that this title is a secure title. So that, unfortunately, is where we are. Now,
just a minute, Judge. When you say we need to clean
Yes.
our registries, how do you think we do that?
we need, our registries, of course, have to go to their records, find out which parcels of land have multiple titles,
Yes.
make a decision on which is a valid title. And that decision needs to be made after looking at the root of title.
Yes.
And we have to, at some point, face that reality. We may not run away from that, because if we do, then it leaves us in a state of, uncertainty on the nature of title that you hold. For example, you see, we buy land, we do a search. Sometimes you do not even know the person who is selling to you the land. And you just need that security that if this title is issued by the government, then it is a genuine title.
Sure.
But unfortunately, Commissioner, that's not where we are.
Okay. Thank you. Thank you so much, Judge. I really wish you the very best.
Thank you, Commissioner.
Sorry, Chief
Follow-up
Justice.
question.
Can I follow up on title, because this is is a judge in that division. Judge, you say that you are the father or the grandfather of root to title.
Yes, in the case of Hubert Martin versus Margaret Kamal, that is the first time you will find root of title mentioned. That is my jurisprudence.
All right.
Yes.
Now, you've read the series of the Supreme Court decisions from Dina, Torino, Semi, and all that,
Yes.
that address several different aspects of title.
Correct.
Now, in a recent decision, Standard Chartered versus Manchester Outfitters, you've read that?
I have read that.
The Supreme Court held at paragraph 64 that a purchaser intending to buy land is bound not only by the principles of caveat emptor or nemo dat non quod non habet, but also by the torrens principles on due diligence. By looking into the details of the register, one could see the status of the charged property. That's the Supreme Court in another matter. Okay? And in this one, it involved a bank and I think a further attacking or something like that of the facility. So it says in this one, just go through the torrent system, which guarantees our system of title, isn't it? So you search and you get to know the owner. So that is number one. Could you say that this is a departure from the earlier series of cases? That's number one. Number two, this concept of root of title, would it affect commercial transactions whereby a bank sells offloads a charged property through an auction, so that the person who buys, the buyer has very little time to go to the root of the title, and he has to, he buys it at the fall of the hammer, isn't it? And won't it be too onerous to commercial transactions and to commerce in general for you to allow or for you to insist on this onerous duty of diligence to the root of title in cases of people who buy property from auctions? Thank you.
In fact, my question
All right.
to the judge is not different from what Commissioner Omwanza has asked.
Very well.
But since you tell us that you are the grandfather of this issue of the root of title,
Yes.
and the problem that I have is that we have now replaced the torrent system of law in which the state gave a guarantee on the sanctity of title. So my concern really is that where do we get that guarantee from the state? Because as it were, you've lifted that burden from the state, and the state no longer gives that guarantee, which as citizen, we expect to get that guarantee from the state. Thank you.
All right. I'll try to marry all those issues together. Now, we have to look at the context of Standard Chartered, because, you see, it was not 2 titles, 3 titles competing. So it was not a case of competing titles. And so it depends on the context of the case. If the context of the case is that you have to determine 2, 3 titles, then really you must get to the root. But if there's no contests on the title, then what is in the register suffices, because it's not disputed. Because if it is disputed, that's when you get to the root of title. But if there's no dispute on the nature of title, then what is reflected in the register, as I'm saying, suffices. So that's a context, and in that context, then the torrents would be applicable, because that is what is noted in the register. Now, when it comes to commercial transactions, now banks, of course, charge titles. and they exercise their statutory power of sale, that's fine. I actually dealt with a case while I sat in Kericho. That is the case of Alice Store versus Nixon, Kipkirui Korir and Consolidated Bank. And the issue in that case was that there was land that was owned by a person who was deceased, and then somebody went and procured a title to that land. Of course, probably thought this person is deceased, I could do something with that land, and he charged that land. And subsequently, the bank wished to sell in exercise of its statutory power of sale, and that's when the family realized, oh, there are some people here coming to value the land for purposes of sale, and they came to court challenging that that title, because it was a title. And the argument that the bank made is that if I am to cancel that second title, then I'm going to be injurious to commerce. But I reasoned that if I do not cancel that title, then I'm actually compounding the problem, because it would mean that all that one needs to do is procure a fake title, take it to the bank, and have it sanitized. And the concept of root of title really is to make sure that it is only the genuine owner of the land who will ultimately be upheld as the owner, not the fraudulent owner of the land. Now, to your question, so I understand the difficulty, because when a person is buying in an auction, I understand the difficulty. You cannot go, I mean, you do not expect a buyer in an auction to start digging, asking who is the owner, and all those things. I understand that. But I think it's more injurious to the economy and to public policy if we are to sanitize those titles, as I am saying. So it is the lesser evil in this scenario. Now, unfortunately, Commissioner, it's just what I've said. Where we are now.
Just before you conclude, is it an issue of public policy, or is it actually judicial legislation? Is it that you are now replacing your views? Because Torrance has been with us for hundreds of years, for so many years. And that is what everybody expects. There's a guarantee from the state to when you go to a land registry that you get a good title.
It is not a replacement of the Torrance, it's an application of the law. If you look at Section 26 of the Land Registration Act, it says that title can be impeached if it is procured by fraud or misrepresentation, where the title holder is culpable. You also find in that section that title that is procured procedurally through a corrupt scheme is also subject to cancellation. So it's not a nullification of the Torrance system. It's actually an application of what the law provides. And as I'm saying, the concept there is that let the genuine owner of the land be the one who remains with title, not the fraudulent owner.
Yes. If I may ask, as a layman,
yes,
where have you shifted now the burden of getting to the root? Because to the best of my knowledge, that should be the lands office. Once the lands office gives me the search and all that, I believe they are the owners of the records and the origin of all that. And if now you are shifting the burden to an ordinary citizen, then where are we? Doesn't your ruling then shift the burden to citizens instead of to where it was in government?
That is the guarantee that the state gave on the sanctity of title by virtue of registration and the carrying out of a search and ascertaining from the green card that all is well.
Yes, ideally, yes.
And Judge, what is this root? What is it? Because it's a concept. Root is not a term of art. It is not found anywhere in legislation. So you tell us go to the root. It's just opening a can of worms, and and leaving Kenyans to actually more uncertainty? Isn't it more dangerous to create that uncertainty through this route, which is not contained in legislation, than to let the state take the burden, so that if there is loss, let the state pay for it?
Now, let's go back to basics, right? Root of title would be source of the title. Title comes from somewhere. It can either come from an adjudication process, that is a lot of freehold land and land like that, or it can come through an allocation process, that is mostly town plots, leaseholds. So that is the root. Must have started from somewhere, did not just come from the air. Now, if you cannot demonstrate that your title came from a source that is acceptable in law, then that cannot be a title that has a good root. That's the concept of root of title. Now, as to whether we are shifting the burden and where the state comes in, this is the reality of where we are. Ideally, the state needs to guarantee that any title that it issues is a good title. That is what the state needs to guarantee, and that's where we need to get to. But we are not there. That's the reality. Now, because of that reality and the reality that there are a lot of fraudsters and we have a lot of fake titles around, that is where the burden of finding out the good root of title comes in. And it is just a concept of due diligence. Nothing more, because as it has been said in past decisions, going to buy land is not the same as going to buy potatoes in Wakulima market. It's different. This is land. So you need to also exercise due diligence. Be careful on what you're getting yourself in.
Yeah, just one thing. Just one thing.
Are you therefore, and you forgive me because I'm now an ordinary citizen. Now, are you therefore annulling the entire Ministry of Lands, its responsibility to give me good title? Because now you are asking me to go and look for a solution elsewhere. Does that ministry now still exist with your ruling?
It still does. It still has titles. But what we are asking of a purchaser is just exercise due diligence. Just go and find out if this is a good title or not a good title. Investigate. That is why we have advocates who would do conveyances. They'll investigate for you. I don't think it's asking for too much, because it's just a matter of being careful. It's just the same way if I came with my phone, I told you, no, this is a phone, please just buy it. You'd probably wonder, oh, why is this person selling the phone? Is it a stolen phone? You'll exercise some diligence before you purchase from me. It's the same thing when buying that.
No, I was hoping that we would move on, since what he's saying has been settled by the Supreme Court. Unless we are opening up the Supreme Court decision, I would suggest then we move away from that.
That's exactly what I was suggesting.
And it is exactly that.
Yes.
That's the position I take. Thank you.
Yes.
Ask the next set of questions.
Thank you, Judge. And for the record, I fully agree with you, Judge. I think that is the right application of the law.
Thank you.
More because this person who is alleging to hold a fake title actually has a fallback to the person who sold to them, so they can always be repaired. I agree with you fully. Now, Kenya's constitutional order recognizes both formal sources of law and non-formal normative frameworks. And by normative frameworks, I mean structured system maybe of rules, principles, standards that guide our lives, our decision making. And they could include national values, principles of governance, and constitutional ideas and ideals under Article 10. In your view, to what extent should such non-formal sources legitimately influence judicial interpretation or the execution of executive mandates? And how should appellate courts guard against the risk of substituting judicial value preferences for constitutionally delegated policy choices?
Very well. Of course, as you say, we have formal sources. We have these statutes, they have set down the law. which is there in black and white. Now, values, of course, are not necessarily hard law in terms of legislation. Where values come in is help you in the manner that you interpret that law, in the manner that you develop it, and in the manner that you apply it to society. So that if the law tells you this, then you have to incorporate with it the values. Is it, do I develop human rights? Do I develop dignity in terms of that? So values, the value of values is in interpretation and application of the law. They do not supplant the law.
We've had instances where judicial officers would refer to some Christian values, religious values, traditional values. To what extent do you think they should?
Only to the extent acceptable by the Constitution. And the values that we have are set down in the Constitution. Now, I have not seen in the Constitution that you can apply Christian values or things like that. I have not seen. So, interpretation of the law has to be in adherence to the values set down in the Constitution. Not personal values. I have personal values, you have personal values, we all have different values. Now, we cannot take those different values, in my opinion, and apply them to the letter of the law.
But my question was on non-formal normative frameworks, which means they are not codified anywhere,
Yes.
but they influence our decision making.
Yes.
So even if you look at the Constitution, you will see something like equity, but it will not be defined.
True.
Yes.
Yes. You see, equity is not law, it's a value. So you can't say law, 1, 2, 3, 4, equity. No. So you use equity, that's why I'm saying you use the values to interpret. So in a certain case, maybe you need to construct a trust. Somebody maybe has let me go back to land, has a title to land that was not properly procured, then you can construct a trust through use of equity as a value. So it's use of value to interpret the law.
Thank you.
Yes, thank you.
Yes, and let me begin where I wanted to begin.
Very well.
Judge, I listened to you talking about your hardware and your soft skills,
Yes.
and I think you left out one soft skill.
Yes.
You want me to tell you which one this is?
You want to say integrity.
You talked about integrity, but you didn't say you're a very pleasant person.
I am extremely pleasant. I am one of integrity, utmost integrity. But you'll remember that the Chief Justice wanted us to move on.
Right.
Yes.
That's okay. Now, Article 168, as you know, provides for instances when a judge...
Sorry, Article
168.
168. Yes.
Provides for instances when a judge may be removed from office. And I would like you, for the period that I've been here, now about 1 year, I don't remember receiving any complaint in respect of your work as a judge, but maybe there has been. I'm not sure. But I would like you to tell us the two ways that one can initiate, a complainant can initiate the removal of a judge.
You initiate removal of a judge by making a complaint to the Judicial Service Commission. And the Judicial Service Commission will investigate that complaint, and if it sees it valid, then it will be escalated to the formation of a tribunal.
So
The
can a complainant make a verbal complaint?
Yes, you can make a verbal complaint to the Judicial Service Commission. That's acceptable. But it's always wise that the verbal complaint be reduced into writing so that it is clear what the complaint is all about. But there's no bar, there's nowhere is it said do not make a verbal complaint. No, you can't make.
It may not say that,
Yes.
but it says it must be in writing.
Yes,
Yeah?
yes.
Okay. The second way?
The Judicial Service Commission itself can also undertake an investigation on its own initiative.
Okay.
Yes.
The Judicial Service Commission can suo moto commence an investigation.
Yes.
Now, when the matter is with the Commission, in terms of the standard of proof, for the Commission to decide whether this matter should go to a tribunal, should refer the matter to the President to appoint a tribunal, what is the standard of proof?
It should be above a balance of probabilities.
Above?
Yes.
Above a balance of probabilities?
Yes.
Again, I'm not so sure whether that is correct.
I stand to be guided.
Yeah, I think we talk about a prima facie case.
Yes.
And finally, when the matter, if a tribunal is appointed, what then is the standard of proof in that tribunal as regards the allegations that have been made against the judge?
I'll repeat, above balance of probabilities.
Okay.
I'll stand guided if that's not the correct answer, but that
Maybe
is
you've never checked.
what is running in my mind.
Maybe you've never checked on these provisions of the law because you've not had reason to do that.
To be honest, I've not.
All right.
I agree with you. And
Thank you.
I'm hypothesizing from my mind.
It is an intermediate standard in between, beyond reasonable doubt, and above on a balance of probability.
Well,
Thank
not
you,
doing too
CJ.
bad, yeah. Thank you.
That standard of proof actually is to be found in a Supreme Court decision of quite recently. So I hope you'll familiarize yourself with that.
I sure will.
I found it very interesting to see that among your sample writings, you have submitted a decision in which you issued a structural interdict. That is in the African Center for Rights and Governance. It was about a dump site, which you even went to visit.
Yes.
And you then issued an interdict. Or did you not? What is a structural interdict?
Structural interdicts are where the court pronounces itself in a manner that the parties need to come back and make a report on progress of what the court has directed them to do. For example, the court can direct that, for example, let's take Murotet, for example. The court directed that the Attorney General, DPP, need to go and come back with a report in 12 months. So that would be a structural interdict. The parties will need to come back and make a report on the progress that they have made.
Okay.
Yes.
So, but you yourself have made some. Maybe you.
I have.
Yes.
Yes.
I thought that was
I just
interesting
can't
to note.
remember quite
Which one?
orders I gave in the.
Yes,
dump
it
site
was
case,
in
but
the
I
county
did.
of Nakuru
Yes.
relating to a dump site.
Yes.
And you had told the county of Nakuru that they needed to clear the dump site if they didn't get a license
Yes.
and to come back to the court to report.
Very well.
Yeah,
Yes.
okay. Let me take you towards the amendment process of the Constitution.
Yes.
Assuming there is an activist or a person interested in amending the Constitution, and what they want to amend is that they would like to divide the county of Nairobi. Say that Nairobi is too big, it needs to be 2 counties instead of 1. What amendment process, what steps would that person have to follow in order to achieve that amendment?
Honorable Commissioner, I need to be honest here. I'm not very precise on the process, but I know it's set down in the Constitution. And to my recollection, there needs to be a collection of 1 million signatures, and it's taken to the counties who debate it, and if they pass it, then it's taken back to the National Assembly for that purpose. But there are some provisions that will require a referendum, in which event then a referendum will need to be called for purposes of passing that constitutional amendment.
Okay.
Yes.
You're correct, and the structure of the counties is one where you have to go to referendum.
Very well.
It cannot end with a parliamentary initiative. One last question: is the right of appeal automatic?
Right of appeal is not automatic. To the Court of Appeal, it's not automatic. It needs to be provided in law.
So can you give us an example of where you cannot appeal to the Court of Appeal from the High Court, for example?
Let's go to arbitration. There are some sections in the Arbitration Act that provide that the decision of the High Court is going to be final. And once that is legislated, then there will be no right to go to the Court of Appeal. So that's one example.
There's no exception?
What do you mean exception?
In arbitration?
Yes, yes.
Is there no right to the Court of Appeal on any ground at all?
There are some provisions that say the High Court decision is final. There are some provisions for that. But there are some provisions within the Arbitration Act that allow for the right to the Court of Appeal. For example, where the parties agree amongst themselves that if they are to submit to the High Court for interpretation of a particular law, then they can agree to proceed to the Court of Appeal. That is provided for in Section 39. So in that instance, then, there would be a right of going to the Court of Appeal. But what I'm saying is that it is not all cases that are determined by the High Court where there is a right to go to the Court of Appeal. It needs to be provided for in law.
Are you familiar with any case law coming from the Supreme Court on the issue of appeals in arbitration? Or
Yes, I am. I've read the case of New to Agrovet.
and what was the holding of the Supreme Court in that case?
What was an issue in that case was Section 35 of the Arbitration Act, which provides for the setting aside of arbitration awards for various reasons, such as incapacity of the parties, and those reasons that are captured in Section 35. And the issue there was, is there a further right from a decision of the High Court, in setting aside or not, to the Court of Appeal? Now, why it became an issue is because Section 35 was silent. Now, it didn't provide that there's a right to go to the Court of Appeal, or did not provide. So that is why it needed an interpretation. And the Supreme Court interpreted it in such a way that it stated that there would be a right to go to the Court of Appeal on the narrow issue of whether the High Court was correct in setting aside the arbitral award or not, based on the reasons that are stipulated in Section 35 of the Act.
Okay. Thank you. Thank you very much.
Thank you.
Good evening, Judge.
Good evening, Commissioner.
Sorry, Chair, sorry. You ought to have invited me to take over. Judge, you can take water if that's okay with you.
I will when I feel the need. So far,
thank you. So far, all is well.
Yeah, I'm okay.
Great, thank you.
Yes.
So you did submit to us academic papers. There's academic paper, conference paper, and decisions that you have written. They show a clear framing of issues, strong application of law and fact, coherent reasoning, and correct use of precedents. It appears from the sample writings you shared, your jurisprudence is formalistic and pragmatic, reinforcing established principle in land, environment, and constitutional law. Conclusions are clear and enforceable. The tone is impartial and professional. Citations are proper. That's with regards to the academic papers. That just shows some level of judicial reliability when it comes to the final orders or the interpretation of the law. There is this paper where you made a presentation before judges in your court, paper on leasehold. You did provide a structured historical and jurisprudential analysis, compared different judicial approaches, and critically evaluated statutory gaps and judicial inconsistencies. It's a well-written paper, and you presented it to your judges, but I feel as though it's something that would have added value to policy. What is your level of engagement with the National Council on Administration of Justice, NCAJ?
NCAJ comprises various stakeholders in the justice sector, this judiciary, DPP, Attorney General, and those various stakeholders. Now, at our level, we engage at the CUC level, that's the Court User Committee level. That is where we bring together all stakeholders within a particular station and discuss issues to improve the manner in which we work, accommodate their issues and things like that. So it's CC level.
Okay.
Yes.
So do you think that such a paper, I know there is time and opportunity you have to factor in, that such a paper is presented at the NCJ, at the council level or at that national level, so that discussions on policy reforms are made, as opposed to just amongst your colleagues? If time allows, if opportunity presents itself.
I hear you. It's just that this one I wrote because the issues were emerging, so I wanted to demonstrate the emerging issues to the judges, my colleagues. But I agree with you. I think we need to have a platform for engagement. For example, we in the Environment and Land Court probably need a consistent platform to engage with policymakers in matters of land, just say Ministry of Land, the National Land Commission. It's a welcome proposal. I think we need to take that up, have that platform, make these discussions, because at the end of the day we are all Kenyans, we can probably contribute something.
Okay, yes. Thank you. I hope the chair and the three other members who are present have noticed that comment. The question that Commissioner Mwanza asked you with regards to whether children have a right to claim land from their living parents, you said from your decision they do not have any claim. How about if it's a claim under customary trust? Can they do that even if their parents are still alive?
They can. That is if they can demonstrate that under their custom, the trust exists. That was in fact pronounced by the Supreme Court in the case of Kiebia.
Okay, I just
Yes.
did that clarification
Yes.
because I always see on social media people discussing that it is not possible, and I ask myself, how about if it's a customary trust?
Yes.
Lastly, Article 10(2)(a) speaks to national values and principle of governance. The most litigated principles are usually issues around devolution, rule of law, democracy, human rights, good governance, transparency, sustainable development. But 2A, patriotism and national unity. Rarely do you find courts speak to those two principles of governance. How can courts litigate patriotism and national unity without collapsing law into an ideology?
Commissioner, it all depends on context. Everything is context. Now, there has to be a context in which the court will interpret patriotism. So it could be, I'm just hypothesizing, that maybe somebody has, say committed espionage, for example, sold out the country, and an issue whether his rights are protected or not can arise, in which event then we can interrogate whether his action is an action of patriotism or not. Or in fact, all those issues, I would say it depends on the context that comes to court.
Okay.
Yes.
So it's not enough for someone to just say, I love my country too much, I had to do ABCD. For the love of the country.
Yes, would say whether that action was patriotic. And maybe it would, invite pardon or things like that. So yes, depending on the context. Yes.
Okay, thank you and wish you the very best. And among the things people love you for or like you for is how you manage your court. You take full control of your court, and all the best.
I appreciate, Commissioner.
Good evening, Judge.
Good evening, Commissioner.
Yes. Lately, we've been promoting the use of multiple doorways to justice.
I want to ask you, which is your favorite and why?
I like mediation. Mediation is good, especially court-annexed mediation, for reason that it attempts to remove the backlog of cases in the judiciary. And it has actually worked wonders. I like mediation.
Okay.
Yes.
Now, the final step in mediation in the process is the settlement agreement.
Yes.
Is that agreement final, or are there instances when it can be challenged? And if there are, which are those instances?
Now, in mediation, what you're trying to do is to direct the parties to agree, which means that at the end of the day, the mediation agreement is akin to a consent.
Mm-hmm.
That would be fine. But remember, just as in a consent, there may be vitiating factors. For example, fraud, mistake, and things like that. So, in the same way that a consent may be set aside, then a mediation agreement can also be set aside if those vitiating factors exist.
Yeah.
And it was pronounced in a recent Court of Appeal decision of Kiboswa, Estate of Kiboswa, that the vitiating circumstances can
Invalidate
lead
the
to the
agreement.
setting aside of a mediation agreement.
Oh, okay.
Yes.
Sorry, I have your report here, your performance report from DISPOP. I don't know if you have had occasion to see it.
Not the current one. I have not seen the current one.
You've not seen the current
I
one?
have not seen the current one.
So I have a report on you from, okay, for the previous years from 2022, but then for the period between July to September 2025, they say you have not met the expected merit resolutions. Now, since you are alone, there's no one to compare you to. I want to basically work with the targets. You said you are currently in Kisii, but moving on to Nairobi, or you already moved?
I reported last week to Nairobi.
Okay, so for the year 2024, 24-25, the calendar year 24-25, you are handling both Kisii and Migori.
Yes, yes, sure.
So the targets per judge, the expected target annually should be 110 judgments annually. I see you nodding. I'm not sure if you're agreeing with me or not.
I'm just not sure of that target. Sorry, I'm just not 100%
Okay.
sure of the target. Yes.
So here it says that in the year 24-25, you had 47 judgments from Kisii and 10 from Migori. I don't know if that is accurate. That makes 57 judgments. I'm talking purely about judgments.
Yes.
Mm-hmm.
Sorry, I was asking which year? Sorry.
24, financial year 24-25, you handled both Kisii and Migori cases.
Yes.
Yes. So the report I have says the judgments you handled are 47 for Kisii and 10 for Migori. That makes 57.
Yes.
So that would be below the target. I don't know if you agree with those results. If you do, maybe you can share with us what challenge you may be facing.
I've just not interrogated the figures, unfortunately, because that was not brought to my attention. But I've not faced any challenges in making decisions. I ordinarily make about 10 or so judgments in a month. That would be my usual average. I'm not too sure of that, of those figures, Commissioner, with respect. I'm just not too sure.
They don't sound accurate to you, or they may be true, but you cannot tell.
Difficult to tell. I was in Migori for about 3-4 months, thereabouts. And yeah, it is possible that I may have done 10 or so decisions. That's possible. I'm not too sure. I'm sorry. I'm just not too sure about the decision.
Okay.
I wish I wish I'd known before, then I could have maybe just verified. I'm just not too sure.
Okay, Judge, thank you, and I wish you well.
Thank you, Commissioner.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you, Commissioner.
I'll read a statement here, and then you'll tell us what you understand by it and your views. A judge should measure twice and cut once. A judge should measure twice and cut once. That is, take time, weigh the choices carefully, and let integrity and public good guide the path to justice. So what do you understand by that statement, and what is your view?
Measure twice, I would equate that to the fact that we have two parties in a case. So I have to measure one's case, and then I have to measure the other person's case. Then I need to cut once. It means I must make one decision, which is final, which I can stand by. That's my breakdown of your riddle. Yes.
Now, and how do you reconcile judicial oversight, independence, and accountability in the context of public resources management?
Sorry, yes, you said oversight and...
Oversight, judicial independence, and accountability.
Yes.
Mm-hmm. In the context of public resources management. How do you reconcile?
Let me start with independence, because independence, especially in the judiciary, is key because you need that freedom to exercise your mind, depending on the facts and the law, without any external influence. Accountability would be a case of demonstrating that the manner in which you are exercising your independence is not arbitrary. It has a basis. That would be accountability. Oversight would be just generally, that position of, guarantee that what I'm doing is right and things like that. That's just generally oversight. Now, in the context of resource management, of course, we have, as a judiciary, we have resources. We have to account for what comes to us. We have to spend the resources wisely. So in as much as we may have some sort of independence in how we spend our resources, we must demonstrate that we have spent those resources wisely. That's accountability. And oversight would inform matters such as audit and things like that, to just demonstrate that we are not wasteful. We are wise in the manner in which we are utilizing our resources.
Mm-hmm.
Yes.
And what legal framework exists for accountability?
We have the Public Values and Principles Act. We have the Integrity Act. We have the Conflict of Interest Act. That's what I would constitute as a framework for accountability as a public officer. Thank you.
The best.
Thank you, Commissioner.
Thank you, Honorable CJ. Judge, I have a few questions for you.
Yes.
I think I'll only ask you two.
Very well.
What innovations or reforms would you propose to improve the efficiency and credibility of the Court of Appeal in Kenya?
Very well. I think, firstly, we must appreciate that the Court of Appeal has a huge backlog. And we need to find a way of reducing that backlog to either zero or manageable levels. Now, one of the things that I would propose is mediation. Mediation is one of them. The other thing that I would propose is a relook at the rules, because we have rules which provide for 3 judge benches. But if you ask me, I would think that some of those provisions which require 3 judge bench may very well be managed by a single judge. For example, a stay of execution application. I do not think you need 3 judges for that. I think a single judge would very well do. Now, if of course we spread that to a single judge, then it means that what one bench would do can now be multiplied by 3. That to me would be an efficient utilization of our human resource.
Any other? Or we go with these 2?
A mediation. And you asked me for 2.
Yeah, okay. All right. I'll read you a phrase and you'll tell me what it means or what your understanding of it. Culture eats strategy for breakfast. Culture eats strategy for breakfast. What is your understanding of that quote?
Culture eats strategy for breakfasts. I would say you have to look at culture. That means what is ordinarily done, and then look at how to give effect to that. That means strategy. So you look at what you need to do, and you find a strategy to do it and to do it properly. That would be my breakdown of your read.
Okay.
Yes.
So how important is an organization's culture in change management?
Very important. You could go into a place and you find it is steeped in a negative culture. Definitely that organization is not going to be efficient, is not going to be successful in the manner it does. And culture change has to be undertaken in that instance. Now you also go to an organization where the culture is good, it's positive, people are vibrant and there's teamwork and all that. And the obvious result is positive in those instances. So yes, culture change is important, but it needs to be in the positive dimension, not in the negative dimension.
Okay.
Yes.
Finally, what do you like most about your job as a judge?
I love my work. This is my calling. That is what I like about it.
Okay.
I do not struggle writing judgments. I do not struggle going to work. I do not struggle working long hours. This is where I belong.
All right.
Yes, this
Thank
is my
you.
calling.
Thank you, Judge,
Yes.
and I wish you well.
Yes, thank you.
Thank you very much, Judge. While you are where you belong,
Yes. I'm at home.
what
Yes.
international or regional professional networks are you part of, and how have they added value to your work?
So sorry, just repeat that. I didn't quite get it.
What international or regional professional networks are you part of, and how have they added value to your work?
As a judge, I am a member of the East African Judges and Magistrates Association. I participated in the last conference that was held in Nairobi last year. I'm also a member of the Commonwealth Judges and Magistrates Association. Now, these are important because they expose me to what other countries are doing, how their systems are, how they manage challenges that they face, and also the kind of jurisprudence that they provide in those courts. So those are the kind of discussions that come out in those regional conferences.
What role do the judicial professional networks play in strengthening standards, ethics, and accountability?
These conferences are a forum to exchange notes. And as I'm saying, they are very, very good forums in picking out best practices that other jurisdictions have in place. So you could borrow maybe practices related to case management. And if I'm to use the last East African Magistrate and Judges Association conference, the discussion was on AJS, alternative justice systems. And out of that, we learned how, say, Rwanda goes about AJS, Uganda, and other countries. And we could borrow and see what nice principles out of those different jurisdictions we can apply here to improve our systems as well.
Thank you very much. Keep the zeal. We wish you well.
Thank you.
Thank you very much. I think, Judge, that was very, very engaging.
Thank you, Honorable
I
Chief
would
Justice.
have wanted to push you on the issue of whether children can also be evicted by their parents from their customary land.
Judge, Honorable Chief Justice, as I'm saying, it all depends on whether there is a trust concept. But now when we're talking of children...
There is no trust concept. It's just
Well,
that they were born there.
Yes.
They have grown up there.
Yes.
They have built their houses there. They derive their income there. They have beneficial interest in the land.
Trust concept comes in. But I do not
I don't think there is trust.
Yes,
It's
yes.
beneficial interests of an occupier.
I would still go down to trust, Honorable Chief Justice. If you can demonstrate, see, out of the way we relate,
Yes.
we can demonstrate that we can construct a trust out of that.
Uh-huh.
You know, if, for example, you are my parents and you tell me, you see that corner, build your house there. You know, I'll not disturb you while you're there. And I build the house. You see, I am now acting on your promise.
Yes, and
So,
therefore,
yes.
when the father wants to sell the land, the son can go to court and say, you cannot sell because this is where I live. This is where I built my house.
Oh yes, because you promised me. You know, you promised me. So that's where we construct a trust. That's where the concept of constructive trust comes in.
Well, I think this case is to be looked at case by case. All right?
Yes, I agree.
There is no fixation. But thank you very much. I think it's been a very robust engagement, and you have demonstrated real passion in the work that you do. This brings us now to the end of the interview, but before we release our candidates, we always give them an opportunity also to engage us.
Honorable Chief Justice, Honorable Commissioners, I am the last interviewee.
We said you are the last,
I am
but
the
not
last
the least.
interviewee. Yes, but not the least.
Yes.
Certainly not the least.
Yes.
We have wrapped this process up. Let me just commend you for the job that you've done. It is not easy. You have sat here for long hours, many days. And I just want to commend you for the job that you've done. You've treated us well. You've treated me well. Thank you so much for that. And I really thank you for this exercise. It's been transparent. And I really just want to say thank you very much. May God bless you.
Karibu sana, Judge.
Thank you.
We wish you well and pray that you keep the same passion and interest in promoting the rule of law in this country. We will get in touch with you when we complete the exercise. It's a very it's a very contentious one.
It's not easy.
Very, very highly contested, yeah?
Yes.
Yeah, but we wish you well.
Thank you.
Thank you very much and have a nice evening.
Thank you. Be blessed. Good evening too.